So, good day to all of you. Our topic for this day is all about corporate dissolution. So, when we say corporate dissolution, it's a termination of the existence of the corporation. So, in corporation, we have different types of dissolution. So, first, we have voluntary dissolution and involuntary dissolution. So, if we are going to identify the different types of dissolution under voluntary. So we have voluntary dissolutions where no creditors are affected. We have also voluntary dissolution where creditors are affected. Another is amending the articles of incorporation to shorten the corporate term. And in case of a corporation sold, by submitting to the SEC or SEC a verified declaration of dissolution. However, on the other side, involuntary dissolution composes of the following. First is by the expiration of the term provided in the Articles of Incorporation, by failure to formally organize and commence the transaction of its business or construction of its works within 2 years from its incorporation. So it's one of the instances of involuntary dissolution. Another is by the order of the SEC or Securities and Exchange Commission and by legislative dissolution. So let's first discuss the voluntary dissolution where no creditors are affected. So under section 118, if dissolution of a corporation does not prejudice the rights of any creditor having a claim against it, the dissolution may be effected by majority vote of the board of directors or trustees and by a resolution duly adopted by affirmative vote of the stockholders owning at least two-thirds of the outstanding capital stock or at least two-thirds of the members of the meeting to be held upon call of the directors or trustees after the publication of the notice of time, place, and object of the meeting for 3 consecutive weeks in a newspaper published in the place where the principal office of the said corporation is located. So, let's pause for this one. Okay, so therefore, the voluntary dissolution could be effected by a majority vote of the board of directors plus a resolution of two-thirds, okay, of the outstanding capital stock or two-thirds vote of the members in a meeting called for the purpose. Okay, so ayan. To continue, if there is no newspaper published in such place, then in a newspaper of general circulation in the Philippines. So after sending such notice to each stockholder or member, either by registered mail or by personal delivery, at least 30 days prior to the said meeting. So after that, a copy of the resolution authorizing the dissolution shall be certified by the majority of the board of directors or trustees and countersigned by the secretary of the corporation. So the resolution is again certified by the BOD and trustees, plus it must be countersigned by the secretary of the corporation. Then after that, the Securities and Exchange Commission shall thereupon issue a certificate of dissolution. So those are the process that must be achieved before the SEC will grant or approve the certificate of dissolution to a certain corporation who experienced dissolution or who wanted to dissolve voluntarily. So the next topic is voluntary dissolution where creditors are affected. So under section 119, where the dissolution of a corporation may prejudice the rights of the creditor, a petition for dissolution shall be filed with the Securities and Exchange Commission. So, you heard it right, kailan po siyang i-file sa SEC. And the petition will be signed by a majority vote of your board of directors and trustees or officers having the management of its affairs verified by the corporate secretary and the president or one of its directors or trustees, and shall set forth all claims and demands against it, and that its dissolution was resolved upon affirmative vote of the stockholders representing two-thirds of the outstanding capital stock or two-thirds of the members at a meeting of its stockholders or members called for that purpose. Therefore, again, the vote required in a voluntary dissolution where creditors are affected is majority vote of the board of directors in resolution of two-thirds of the OCS or two-thirds of the members in a meeting called for that purpose. Okay, so the petition will be verified by the SEC for the dissolution of the corporation, and thereafter the SEC will hear the petition and try any issue made by the objections filed. So after that, if no such objection is sufficient and the material allegation of the petition are true, the SEC shall render the judgment dissolving the corporation and directing the disposition of its assets as justice requires, and may appoint a receiver to collect such assets and pay the debts of the corporation. So if it is found that it's just that it needs to be dissolved, so papayagan na yan, bibigyan na ng signal ni SEC yung corporation applying for voluntary dissolution, however the creditors are affected. Okay, so pwede silang mag-appoint ngayon ng receiver to collect such asset. Okay, and pay the debts of the corporation. So those instances will happen if there is voluntary dissolution and if there were creditors who are affected to the dissolution. In addition, if the petition is sufficient in form and substance, the Commission or the SEC shall, by an order reciting the purpose of the petition, will fix a date on or before which objections thereto may be filed by any person, which date shall not be less than 30 days nor more than 60 days after the entry of the order. So before such date, a copy of the order shall be published at least once a week, okay, for 3 consecutive weeks in a newspaper or general circulation, published in the municipality or city where the principal office of the corporation is situated. Or, if there is no newspaper, general circulation po in the Philippines. And a similar copy will be posted for 3 consecutive weeks in 3 public places in such municipality or city. So, ganun po yung magiging proseso if ever there will be a voluntary dissolution. So, they need to inform the public. Kaya, meron tayong publication in the newspaper. Okay? They need to inform the public that the corporation will be exercising voluntary dissolution and they're informing the creditors, diba, to exercise their rights or claims against the corporation. So, and this is a method also or a process made by the SEC to protect also the creditors. So, kailangan meron siyang general circulation, okay, or newspaper publication for 3 consecutive weeks. Okay, so those are the voluntary dissolution where creditors are affected. To proceed, if the cause of the dissolution is by shortening of a corporator, so according to section 120, this will be effected by amending the articles of incorporation to shorten the corporate term. Okay, so after that, it needs a copy of the amended articles of incorporation and this will be submitted to SEC or the SEC. And upon approval of the amended articles of incorporation or the expiration of the shortened term, as the case may be, the corporation shall deem dissolved without further proceedings. So you heard it right. Kapag na-approve na po yung amended articles of incorporation or expiration of the shortened term, okay, the corporation shall be deemed dissolved without further proceedings. So that's what will happen if there is a dissolution by shortening of corporate term. Kaya nga, 'di ba? Any stockholders whoever don't want to agree with the shortening of the corporate term will exercise or can exercise their appraisal right. Okay? So that is dissolution by shortening of the corporate term. So we are done with the voluntary dissolution. Let us now proceed with the involuntary dissolution. So we have different grounds for dissolution under involuntary dissolution. So first is the non-use of corporate charter as provided in Section 21. So if a corporation does not formally organize kasi and commence the transaction of its business or construction of its works within 2 years from the date of incorporation, its corporate powers shall cease and the corporation shall be deemed dissolved. So that will be a grounds for involuntary dissolution. Aside from that, if there is a continuous in operation of a corporation as provided under section 21, so in operation, so after that there will be also involuntary dissolution upon receipt of a lawful court order. Okay, so dissolving the corporation, actually that is a dissolution or involuntary dissolution by legislative enactment. Okay, so a corporation may be dissolved by an act of the Congress subject to limitation that no right or remedy in favor or accrued against any corporation, its stockholders, members, directors, trustees, or officers, nor any liability incurred by any such corporation, its stockholders, members, directors, trustees, or officers shall be removed or impaired either by subsequent dissolution of such corporation or by any subsequent amendment or repeal of this code or any part thereof. So that's involuntary dissolution when there is a legislative enactment or through a lawful court order dissolving the corporation. Then, aside from that, it will be involuntary dissolve if there is a finding by final judgment that the corporation procured is incorporation through fraud. Okay? And upon finding the final judgment that the corporation was created for the purpose of committing, concealing, and aiding the commission of the securities violations, smuggling, tax evasion, money laundering, or graft and corrupt practices. So if that corporation was formed because of fraud, okay, and any activities that is prohibited under the law, then it will be dissolved. Aside from that, when there is commitment or aided the commission of securities violations, smuggling, tax evasion, money laundering, or graft, and stockholders knew the same. So, it's more of connivance kasi. The stockholders knew it, tapos ito yung ginagawa ng corporation, and then it is repeatedly and knowingly tolerated the commission of graft and corrupt practices. So therefore, that's enough grounds or bigger weight of grounds to dissolve the corporation. So if the corporation is ordered dissolved by final judgment pursuant to the grounds set forth in the subparagraph 5, its assets after payment of the liabilities shall upon the petition of SEC with the appropriate court be forfeited in favor of the national government. Yes, you heard it right. So, ifo-forfeit yan ng SEC. Such forfeiture shall be without prejudice to the rights of innocent stockholders. So they are protecting the innocent stockholders and employees for services rendered into the application of other penalty sanction under this code or other law. So poprotektahan nila yung mga innocent stockholders and employees. Then after that, if nabigay na nila kung ano yung just and equitable for those who are innocent ones, then the other proceeds of the corporation will be forfeited in favor of the government. And the Commission shall give reasonable notice to and coordinate with the appropriate regulatory agency prior to the involuntary dissolution of companies under their special regulatory jurisdiction. So those are the grounds for involuntary dissolution. We are now down to our last topic, which is corporate liquidation. So liquidation is the process of winding up the affairs of a corporation and entails the collection of all assets, the payment of its creditors, and the distribution of the remaining assets, if any, among the stockholders in accordance with their contracts, or if there be no special contract on the basis of the respective interests. So the manner of liquidation may be provided for in favor of the corporate bylaws. Okay, so pwede siyang ma-state doon sa bylaws. And this would prevail unless it is inconsistent with the law. So kung hindi siya consistent with the law or hindi siya parallel to the law, okay, so hindi siya magiging effective or valid. So after dissolution, the corporation shall nevertheless continue as a body corporate for 3 years, not for continuing the business for it was established, but for the following: A. To prosecute and defend suits by or against it. B. To enable it to settle and close its affairs. C. To dispose of and convey its property and to distribute its assets. So we have different methods of liquidation. So we have liquidation by the directors themselves or through board of directors. So under section 139, it prohibits a dissolved corporation from continuing its business for which it was established but allows it to continue its existence for the limited purpose of settling and closing its affairs. So, yun, stop na yung operation pero yung transaction is more of settling of and closing its affairs only. Necessarily, there must be a board that will continue to act on behalf of the dissolved corporation for that purpose. Okay? So, most probably, yan yung liquidator. Okay? Ayan. This section authorizes the dissolved corporation's board of directors to conduct its liquidation within 3 years from its dissolution. So, actions pending by or against the corporation when the 3-year period expires are abated, or after the said period, the corporation becomes defunct and ceases to be an entity capable of suing and being sued. Therefore, the law does not allow any extension of the period. Okay? Kasi nga, liquidation na siya. Okay, however, a creditor with a pending action against a corporation or a corporation with a pending suit filed, but it may be prevented by the abatement by asking the proper court for the apportionment of a receiver or trustee within the winding up period. It could also be liquidated by a duly appointed receiver. So, the receiver will be responsible in settling and winding up of its affairs by the liquidated corporation. Being merely a ministerial officer, a receiver of the corporation has only such authority as is conferred by the statute. Okay, ordinarily, he may sue to enforce the stockholders' liability on unpaid subscription and representation of the corporation. A call is considered a prerequisite to any action that a receiver may take to enforce unpaid subscription. So aside from that, the appointment of a receiver operates to suspend the authority of the corporation and its directors and trustees over its property and effects. So, the moment na nag-start na yung receiver in liquidating or in handling the corporation's affairs, so the property and other authority is being um, restricted. Okay? Such authority being reposed in the receiver and in respect to the receivership is equivalent to an injunction to restrain to the corporation's officers from intermeddling with the property of the corporation in any way. And aside from that, liquidation could be done by trustees to whom the board of directors had conveyed the corporate assets. So the same rules governing the duration and the time of filing of claim where the liquidation is done by a receiver apply to the liquidation affected by a trustee. So it could be through receiver, it could be also through a trustee. So those are the process or processes in terms of corporate liquidation. So that is the dissolution and corporate liquidation of a stock and non-stock corporation.